should consult a doctor as soon as possible and follow his or her prescribed treatment. Costly mistake number 2, waiting too long to apply. Once you, through consultation with your doctors, have determined that you may be unable to work for a period of 12 months or more, you should file for benefits immediately. You could risk losing benefits to which you're legally entitled by waiting longer than necessary to apply. Costly mistake number 3, waiting too long or failing to appeal. If you've already applied for Social Security disability benefits and you've been denied, you most likely received a letter notifying you of this denial. Towards the end of that letter, there's a paragraph telling you that you have the right to appeal your case. This paragraph states that you have 60 days from the date of the letter to appeal your claim. Costly mistake number 4, using illegal drugs or alcohol. Social Security claimants who abuse illegal drugs and alcohol risk losing their entitlement to benefits. Social Security laws can prevent you from receiving disability benefits.
Going back to what was that initial application, and in this video, Steve, I want us to talk a little bit about what that application process is, how do we help claimants to go through that process, and why it's important to have an attorney or an advocate be on your side when going through this process, because as you know, these disability insurance companies are often looking at paying out hundreds of thousands of dollars to a claimant, and it's right from the get-go that they're most looking to not pay that claim. So, let's start out of the box as to why it's not just as simple as filling out those forms that the disability carrier sends to a claimant.
Well, the forms seem simple enough, self-explanatory, but they are set up in such a way to see if they can find ways to punch holes in it. I think even the attending physician statements you may get on a monthly basis, if you look over, you notice it doesn't really a lot of times speak as to what the conditions may be or give the doctor a lot of room to even express opinions. So these forms, they may be asking for simple information, but something as seemingly minuscule as possibly putting the wrong date of disability can completely affect your claim when they go and they evaluate, were you working that day, were you doing your duties? So it may seem benign and not too problematic or in-depth, but the companies are really from the get-go trying to find a way to either figure out how they can deny a benefit if possible, or they're even setting up, if they're going to approve it, what's the quickest way to try to get you back to work so they don't have to pay
the return to work, aka denial date, is what we usually see. So let's back up a second. There's two types of policies that we help people with, or two types of law. There's the ERISA governed policies, which are usually the employer provided benefits, and then there's the individual disability policies, which are the ones that people either bought on their own from an agent or they got through an association like an American Dental Association or General Surgeons Association or accountants, things like that, which are not governed by ERISA. And there are significant differences in those two, but at the end of the day, the way that you apply ends up being the same. So we won't necessarily talk in this video about the ERISA nuances, which we've done tons of videos on that. So let's talk more generally about applying for benefits. Now, when we were talking about what do we really want to talk about in this video, we were saying how most of our clients who apply, the ones who get hit by a bus or have some real catastrophic injury, those are no-brainers, and those are far and few in the claims. The real claims that happen are the people who have been working for years, have chronic conditions, and then apply. Yeah. And as you just said about a minute ago, was what is that date of disability?
Social Security will ask, are you working? If you are working, Social Security will find that you are not disabled at this step. If you are not working, you will move to step 2 of the process. Step 2 asks the question, do you have a severe impairment? If you are found to have a severe impairment, you will move to step 3 of the test. If you are found not to have a severe impairment, then you are found not disabled. Now, you may have many medical conditions. Only one of these medical conditions must be found severe to move to the next step, even though all of your conditions must be considered when ultimately determining if you are disabled. So what is a severe impairment? Social Security defines severe as a medical condition that limits your ability to do work-related activities. Significantly limits your ability to do work-related activities. So if it only minimally interferes with your ability to do work-related activities, it would be considered a non-severe impairment. Now let's move to step 3. Step 3 is, does your medical condition or one of your medical conditions meet or equal a listed impairment? The Social Security Administration has a list of medical conditions, and if you meet the criteria